So everyone, we are the starting session. Our aim is to try to set a foundation that will help us as a group talk through and think about the way these markets work, the way they don't work, and at least put the issues out there so that we can then discuss later in the conference how and whether or how the SEP regulation may actually help us, whether other things are needed, and to set a baseline for the discussion that comes. We're going to start with Joachim Henkel from an academic perspective, and then, as you can see, the great news is I don't have to go and talk through everybody because they're all identified up there, and we don't need to lose much time before we get to the real content. The idea is I'll ask some questions to each speaker to bring out their particular perspective. We'll have a bit of an exchange as we go through. I had hoped to have another quick roundup afterwards, but I suspect that since we're already running a little bit late, we may not have that much time. But shall we go? So, Joachim, to start us off, from an academic's perspective, can you give us your perspective of how these SEP markets work, and in your view, how well are they working?
Yeah. Thank you, Christopher. I will state some basics that will bore some of you, but there are also others here who are not familiar with the field. So, a standard, what is a standard? A technology that is needed, that you can't circumvent if a company wants to be active in a certain industry. If you want to build smartphones, you have to use 5G. As a consequence, an owner of a patent on this standard has high market power. In principle, you could use a single patent to block the entire standard. This is not good. For that reason, the antitrust rules and also the friend commitment makes sure that patent owners are willing to license those patents at a so-called friend rate, fair, reasonable, and non-discriminatory. The friend licensing process is subject to certain rules laid down in 2015 by the Court of Justice of the EU in the Huawei ZTE judgment. So, notification of the infringer by the patent owner, then signaling of willingness to take a license by the implementer, then an offer, which should be a friend offer by the patent owner, then the reaction by the implementer, say either okay or no, and here's my counter offer, and if that is rejected, then a security, and then what goes on, it might go to the courts. Courts might then, in some cases, and that's an important topic, set royalty rates. Courts in the US, UK, China have done this. Courts in continental Europe tend not to do this. They would sometimes hand out injunctions, or the case might be decided in other ways, like in invalidation, for example. But in any case, also injunctions obviously influence highly the licensing price because they give strong negotiation power to the patent owner. On a practical level, just for those who are not familiar, there are many, many patents for 5G. More than 60,000 families have been declared essential. Maybe 20% maximum of those are really essential, hard to know. Fragmented ownership for 5G, something like more than, I think, 100 or so organizations have declared some patents. So very difficult to cover all. Assessing the quality of a portfolio is difficult. So if somebody gets an invitation to take a license and the portfolio description is sent, very hard to assess if a patent is really essential for a standard, if it's a good or a small technical contribution, if it's valid. For somebody not from the field, it's impossible. For somebody in the ICT area, it's still very hard and expensive. Prices are usually not announced publicly. Exceptions are pools like Avanci for 5G, 4G. For some standards, pools exist, but Avanci is really an exception with covering most of 4G and 5G. That's rare. What influences the outcome on the licensing market? First, I don't think it's a market really, because it's a bilateral monopoly, each case between the patent owner and the implementer. Patent owner has to license, the implementer has to take a license. So it's not really a market. So the claim that the market solves any remaining issues is not quite correct, I think. Negotiation power matters a lot. Deep pockets, litigation experience, also reputation for going to court, one way or the other, of course. And court decisions. So all negotiations are in the shadow of the courts, for good and for bad. So, I mean, one thing is that licensors these days knows they shouldn't better delay. They should better not delay, I mean. To be an unwilling licensee before the UPC or other courts would not be good. And that's good so, because there has been quite some abuse of that. On the other hand, there may be such a fear of an injunction that people don't even go to court, even though they think it's usually excessive, a license demand. Does the market work well? Well, it works somehow. We get new phones with 4G, 5G, probably soon 6G at some point. Does it work well? Not really sure. For smartphones and similar devices, it works reasonably well, let's say. In other areas, notably IoT, and this is getting hugely important, it does not work well. And the fact that most agreements are closed without litigation, and we don't see that much litigation, obviously there are not that many courts and they don't have that much time, that doesn't mean it works well. It partly just means implementers can't afford to sue, or maybe also the patent owners may want to avoid it for all sorts of reasons. Particularly for smaller firms, and IoT is highly fragmented with many small firms who are, well, small, possibly. In any case, IoT mostly have no understanding of the technology. And if these are then confronted with a licensing request, unless it's for an entire standard, then they can say something. But if it's for a portfolio, they're essentially lost. That doesn't work well. And there are cases, it's very hard to get numbers. I tried in my research. There are cases where firms said, oh, getting out of this. We can't use that technology because it's too much risk. In brief, there's a lack of transparency about the standard, about the patents. The royalty thing is a question, I think, my feeling is it's often excessive for SEPs because of the negotiation power of patent owners. The licensing level is a big issue. The common licensing level is at the level of implementation. For smartphones, SEP owners have established device-level licensing. It works more or less. I don't think it works for the IoT space. And by the way, the regulation has reference to that in paragraph 16. Thank you. Sorry.
Thanks very much, Joachim. I'm sort of looking around. I'm seeing no one jumping out. So can we go to Carole? So you're speaking from a perspective, in this case, as a SEP implementer. Mm-hmm. What would be really helpful to understand is essentially, what do you need to negotiate a brand license successfully? What's the information you need? What are the other challenges? How does this work for you?
Right. Information and trust, I think, are kind of two words that come to mind when I talk about a negotiation. In a negotiation, I think, Joachim, you talked about it's a bilateral monopoly negotiation, but in my mind, it's actually many to many. There's many patent owners that I might be negotiating with at the same time, but I also have multiple suppliers that I'm also on the back end negotiating with. Are they going to stand behind their indemnification obligations? How much is their apportioned obligation for that? And there's an internal negotiation for that as well. Understanding that there's this many to many coming forward into a license agreement, and I think I best heard it as herding cats is one way of describing that together. But clear and trustworthy information can help bring these many parties together, and education and knowledge. And so in some ways, I think the transparency of the EU regulations can be very, very helpful in negotiations in the past. If I added up all the asserted I would say, patent ownership claims of all the people coming after the companies that I've worked for, you would get 147% of the market is owned by the patent owners. and so coming to an understanding of what is baseline, what patents do you have, which ones are essential, what percentage of the market is that, and what are the comparables, so that I can go to my leadership and my indemnitors and say, yes, we are not going to be disadvantaged against our competitors, and will stand behind paying a reasonable, fair, reasonable, and non-discriminatory royalty for these patents. But again, my leadership is not so much into the legalese of friend and all of that. They just want to make sure that we're paying the same rate as our competitors. And how do we do that in a trustworthy way? Also, I don't want to pay a royalty twice, so it's good to know which patents are part of the pool or which patents are owned by the patent owner. I've had people ask me, well, Carole, tell me all your suppliers and your suppliers of your suppliers, and then we'll tell you which ones you're double, already licensed to. So one, there's a trust issue there that I can't verify. And second of all, if I tell you my suppliers, that doesn't necessarily tell you all the patents that my suppliers may own historically that may have been purchased from somebody who is already part of the pool. And so there's an information gap there or misunderstanding in terms of what do I need. I need good information, but verifiable information that I can use to build trust, to actually close a deal and get approvals from my internal leadership, but also my indemnitors. It's a small ask.
No, I mean, to me, it's fascinating because the issue of just not being able to go up to management and be able to say, this is a good deal versus a bad deal, and it's in any event, it's not worse than our competitors are getting.
Right.
Does anyone have sort of reactions to that first before?
Yeah, I would like to say something about that, because I think what Carole's saying rings true, but in a different way with me as well. And this is the topic of indemnifications that we see very often. We go to companies that rely completely on an indemnification, but they don't realize that those indemnifications are often not backed by an actual license. So they give the guarantee that if you're being sued for infringement of a patent, we will take care of it, but they didn't take a license. They may not have the intention to take a license, but they are selling it to, especially we see this in the IoT field, that is being sold as something that is equal to a license, same kind of protection. And this is a very intransparent situation for the buyers of these kind of products, because they think they have an indemnification, but they don't have any kind of qualification who they are licensed to. So when we knock on their door, because we manage 50% of 4G patents in IoT, in cellular IoT, and we often get the response, yeah, but I'm covered already. My supplier gave me an indemnification and I'm relying on this 100%. And one of the things that we notice in these kind of discussions as well, when we do close licenses with companies, and I think that this is where the strange process of disclosure is coming from, is that the licensees often insist on confidentiality of the license. They don't want the world to know that they took a license. They think it looks bad on them. It reflects bad on them. They're afraid that more patent claims may follow, etc. So they want to remain confidential when they actually took the license, which means that if Carole wants to know who is licensed, the licensor may be in a position, well, sorry, I can only tell you who is not licensed, because with those companies, I don't have confidentiality obligations. So it is an intransparency there, which is kind of coming from both sides, I think.
Okay. Julia, over to you.
Sure.
I think very much so. Julia, from perspective of an SEP licensor, what are the obstacles to getting a quick agreement? And I think we may have heard some of them, but likewise, what are the factors that you think about when you're deciding, do I give up on this negotiation? It's not working. Do I move to litigation? I mean, how does that thought process work for you?
Right. I mean, when it comes to concluding a license agreement within a reasonable time, I think if we start from the basics, the lack of awareness, like some of our panelists have mentioned, is a big issue. So knowing that the implemented standardized technology is actually a proprietary right, and they have to allocate those financial reserves to pay for the license sooner or later. It's an important aspect. We see that with many implementers, but particularly with smaller with IoT. They are not small companies, but probably they haven't thought about it, and that's an important aspect. Also, as Carole and David have mentioned, the indemnification clauses, we see that, I've seen that, and this causes actually spillover. This issue has a spillover effect, and it burdens parties during the negotiation. Then also with confidential information, having the suppliers involved and participating in negotiations. Sometimes it's another issue, but and then when it comes to when maybe the parties are already aware that they have to sooner or later negotiate a license, it's the actual willingness to take a license, and for many reasons, sometimes that happens, sometimes it doesn't. So that's this can definitely negatively impact the time it takes to negotiate. One thing also I'd like to note, having outside counsels participating and representing the parties, almost I would say from the very beginning, it's quite difficult to get to the details of the negotiations, because often you need the industry the industry representatives to be there at the negotiating party, because friend licensing is a commercial license. Involves commercial terms, so you need to get the parties involved, and having outside counsels, it's good, especially if you don't have experience in friend licensing, but it's also a frustration. And I've been there, so I can note that. Now, when it comes to deciding on whether we should start any litigation, we are also a big implementer, so and we don't want to upset market players, but it is an important aspect to SEP licensing. It's inevitable, but the majority of the negotiations, they end up amicably, and so that's okay. More than, I heard, 95%. But one thing is, if they are clearly unwilling, not responding, not engaging, and then the time it has taken until now, we will consider that. But also obviously the friend's position. And the other thing, and that's a very important one, it's, after many rounds of counter offers, if the two parties are too far apart, it's an indicator that we might need to go into litigation. And then obviously we have to assess, but we won't litigate against a small player against a small SME. That's just not financially viable. Just to make, and that's, and I think then one thing I would like to note also on the negotiation, it's on transparency. It's a very important fact for transparency, and also with the competitors, for the implementer to know who is paying and who is not. But that isn't always possible, like David Muus has mentioned, also with patent owners. Having to disclose who their previous licensees are, but also the commercial terms. It is difficult, and even when it comes to comparables, it is difficult to address comparable licenses because it involves commercial details, and so it's difficult to compare.
Thank you very much. So, as the only outside counsel on the panel, I have to come back on that one.
I knew this.
So I actually have a lot of sympathy with what you said, in that you're right. The outside counsel role, there are two things that go on. One is the joy of legal privilege is you get to tell your client directly what the rules really are and how bad their situation really is. So yes, that can contribute. Obviously, you won't see it from the other side of the negotiation, but it happens.
Yeah.
On the other hand, I also see the frustration. Certainly, we see this when you see the letters going or the emails going from one side to the other that are sort of this long and have everything contested on all possible sides. There's a reason for that, though, and the reason is the way the German courts have implemented Huawei ZTE, where the German courts deliberately use this as a trap to catch the implementers and to grant an injunction. So literally this, because of what they're doing, they have turned the negotiations into pre-litigation. So every exchange is written with a view to, are the German courts going to pick on this and say, oh, look, he's unwilling because he didn't say this or he did say that or whatever. That's the reality. That's why you get these stupid exchanges in the negotiations. So I do have sympathy. Yeah. It's not our fault.
No, I understand. That's why I said, especially if the implementer negotiating.
I have to say, I mean, I don't really believe that judges are in the business of setting traps for companies. I just don't believe that.
I've never had a client who wasn't found unwilling by a German court.
Well, sure. I mean, but maybe you have a certain selection of clients, or there's some selection bias, I guess. But I mean, the whole point is, I think what you see in these long conversations, I don't like these either, because I don't think that they are directed to a commercial solution. I don't like, but sometimes you're trapped in those kind of discussions as well, where you get like buckshot shot at you, and you have to dodge every bullet, because it's very obvious that they're going to try 1,000 arguments to say no. So that is a reality. And if that process goes on for 2 years, at some point in time you have to say the buck stops here. And then you go to a court. And the court will see, well, these guys have been trying for 2 years to give this company a license, and you're just finding always another reason to say no, and I'm just not buying it. Yeah. I don't call that a trap.
Yeah. So that much, no, I agree with that. And clearly, the challenge for this whole SEP licensing issue is that there clearly is a point at which the negotiations need to finish and the litigation has to begin if you can't get there. And the challenge for us is to facilitate those negotiations process. And what I heard a lot earlier was one of the real problems is nobody knows the things that are essential to know. There's a lot of friction in the way of getting a good, quick outcome. But sorry, Julia, you were about to come back.
And I said, go
no,
on.
passed on.
Yeah. No need to spend time on it.
Maybe we should go to Lukas, who can offer us a particular perspective from the outlook of smaller players, entrants in the industry. How do they approach SEP negotiations, and how you see the outcomes for the smaller players and entrants compared to more established players? So here we're not talking to a degree we're talking about the dynamics between the patent owner and the implementer, which is most of what we've heard so far. But what we're going to hear now is, to a degree also, the consequences in terms of competition between big players and small players on product markets.
Thank you, Christopher, for your question. So I think smaller implementers overall approach SEP negotiation very much like Carole would, just with more constraints and overall less means. For small companies, the focus is not just on securing licensing terms, but also on ensuring that reaching an agreement, the negotiation process, but also the final agreement, does not undermine our ability to compete with larger incumbents, some of which are in the room. Unfortunately, the outcomes for implementers, as we see them currently, tend to reflect systemic disparities, as we find it overall harder to compete when it comes to SEP licensing and secure fair terms, which often results in us paying higher costs for similar technologies as our competitors would. I think there are 3 key hurdles that we are facing. The first hurdle comes from the disparities that we see in PLAs. SEP rates have been frequently considered by courts as supra-friends lately, and this has an unfair impact on small licensees. A good example that I, as Fairphone, can talk about is what happened recently with the Lenovo case, where the courts determined a global frame rate of 22 cents per unit for 4G portfolio of InterDigital, while in contrast, Fairphone's disclosed rate was of 69 cents. We are talking about 3 times the frame rates that we have paid for years. While I understand that volume-based considerations are very important, as they are in any industry and any markets, it seems to me that the disparities that we see in SEP licensing often are not easily justified by mere transactional cost and economies of scale for SEP holders. Larger implementers have the opportunity to use their larger volumes to spread licensing costs over these volumes, while smaller parties like Fairphone with much lower volumes, well, we have to absorb these costs. This creates an uneven playing field in some markets, and notably in our smartphone markets, and this puts us at risk of being priced out of the market at some point. Don't mistake me. I do think that patent holders should be incentivized to innovate by ensuring fair returns, because you have put the investment in R&D, and that benefits entire industries. But imposing super friend rates on small licensees does not necessarily seem to serve a purpose of ensuring fair returns. Rather, it often seems like it allows patent holders to set higher comparables when entering into negotiation with larger implementers. And that is a bit where we as smaller companies see the struggle, is that we feel used sometimes as just a negotiation tactic. Beyond rates, there is also a significant hurdle that we are facing with regard to portfolio composition. I think everybody has heard of the studies where out of any given portfolio, roughly 20% of the patents are considered truly essential. That places a seed of mistrust in the negotiations for us, because from there on, we must have some concern about whether we are paying for the right patents. And an easy way to solve that, you would say, is essentiality checks. But essentiality checks are extremely costly, and often smaller implementers don't have the resources to enter into these discussions. 7,000 euro, I think, was the rate put by the impact report for an individual patent assessment, and we often have hundreds of patents to assess. These are just not investments that we can make. And that puts us as smaller implementers in front of a dilemma. Either we can accept the initially offered license rates, which may include non-essential patents, and take the risk of paying super-friend license fees, or we can invest in costly essentiality checks, for which we won't be sure about the results, and these may also result in us paying ultimately a higher cost than with the initial offer. Smaller licensees are also quite disadvantaged in the context of provision accruals, and I think that's something that has been touched upon. Because as noted in the Lenovo case, willing licensees make provision for the sums which will have to be paid in due course, and that's what we are, a willing licensee. Without reliable benchmarks for friend terms, what we are obliged to do is to accrue these sums based on the headline rates during often drawn-out negotiations. Smaller companies don't have the resources to adjust rates based on essentiality or on the potential true value of a portfolio. Just to put this element into perspective, taking the previously mentioned court-determined friend rate of 22 cents and compared to the license rate of 69 cents and a hypothetical negotiation period of 4 years, that would have led us to accrue $150,000. When you're operating a company on a very tight budget, these frozen funds could have been used and represent missed opportunities for scale, for innovation, or in Fairphone's case, for social impact. This issue has further been magnified by the fact that UK courts recently have permitted SEP holders to also recover sums beyond the statute of limitation. And while this is fair, this also weakens one of the key tools that small licensees had to adjust this provision during drawn-out negotiations. Patent pools, I have to say, have significantly allowed us to progress on these issues. by offering greater transparency and facilitating access to comprehensive licenses, which was more difficult before. However, we still struggle with concerns about non-implemented SEPs in Pool's portfolio and sometimes the limited scope that may miss some of the important license source for a particular technology. And ultimately, as I think was mentioned earlier this morning, again today, small implementers just don't have the resources to litigate. If we look at the recent court cases and the litigation costs that ensures, we're talking about millions. This is just not an option for us, and that puts us back in this dilemma of either paying higher, potentially supra-friend rates, or investing in essentiality checks that may not yield the results that we desire.
If I may comment, I would like to point out one thing. You repeatedly said supra-friend rates. Mm-hmm. And what you meant was the fact that Fairphone was paying higher royalty rates than others. So you meant supra-ND, so more than non-discriminatory, because it was discriminatory. The question if the rates that also the others pay, if they are FR, fair and reasonable, this is untouched. I mean, and this is also where the regulation has good provisions for ensuring ND through just transparency. But the question, what is actually fair and reasonable, is extremely difficult because, well, courts, for obvious reasons, they love to refer to comparable licenses. But it just means then doing what others have done before, ensuring in the best case non-discriminatory, but fair and reasonable, I don't know. It's questionable, I think. Last point, the guidelines of the EU on the interpretation of Article 101 TFEU, paragraph 289 referred to the possibility of looking at development cost. I think that would be interesting to do, even on an aggregate level, to estimate what's the cost of developing a certain standard and what's the return on invest that people get. My hunch is it's extremely high, and probably higher than it should be to be fair and reasonable.
Lukas, could I ask a question coming from a sort of a story that I had? So I once had a client who, at the early stages of its business, launching, trying to get funding from venture capitalists, they had a particular issue in that they took the view that they couldn't afford real disputes with patent owners. Does that ring any bells with you? And could you give us a perspective on that?
Yeah, definitely. So I think ultimately when, as a small implementer, we receive a high initial license, or let me rephrase, an initial offer that we consider perhaps too high, we have to take a business decision. Either we decide to take it as is, or we decide to fight it with whatever means are available. When we are working with small volumes, often the quick answer for our management is just take the hits and try to reduce costs somewhere else. Litigation is just currently too uncertain and we don't have enough information, so that also just opens a whole rabbit hole where we don't know how much cost we will have to spend into eventually fighting it. So that very much rings a bell for me.
Okay.
It's an interesting notion because this was actually a discussion that I had just during the break before. Would a sort of small claims court help you? So, for example, you see this in the UK where there is a small claims court for IP disputes?
I think what would really help is a mechanism like what is currently proposed by the new SEP regulation, well, the SEP regulation proposal, where prior to litigation there would be an independent friend determination that is made. And whether or not we conflate that with a small courts claim, I think that is what really is at the core of the problem, is the lack of information about actual comparables and the lack of independence or the lack of trust that we often have in the rates that are offered to us.
Okay, before we move to David, I think we have caught up on time, so we will have time for a couple of minutes from everyone at the end, just to warn you.
You haven't heard me yet.
So, David, obviously to a degree, everything on the implementer side applies, so on the SEP owner side applies to you, but you also have a perspective as a pool licensor, and I was wondering if, when you put in your perspective on this, if you could give us some insights as to whether there are any differences that brings, as you view licensing, and how you deal with published pool rates and demands for discounts off those pool rates, and how do you, this whole non-discrimination issue, how do you cope with that as well?
Yeah, so maybe I start a little bit with where the negotiation starts for us. Because like you say, I mean, we are a patent owner in our own right. We own patents as Sisvel, but it's usually patents that we always put in our own pools. So it's usually part of a pool, something that we see is becoming available in the market, and we don't want that to wander off. We rather have that within our pool. And for us, the negotiation on a pool license starts with the patent owners when we form the pool, because we need to bring all these companies together. We got smaller pools. We have our Wi-Fi pool where there's 6 or 7 patent owners coming together, but those 6 or 7 patent owners represent effectively 80% of all the patents that are actively being licensed. But we also have very big pools, like our cellular IoT pool, where we have more than 30 patent owners together, representing about half of all of the patents in the 4G low power market. And these negotiations, they start to bring these patent owners together, explain them, look, we understand that licensing in this field is messy. There's multiple licensing requests coming around. There is this intransparency. There's these companies like Lukas is representing that don't really understand what's going on and they find it difficult to manage. We think there's an opportunity for us here as Sisvel to build a pool and create some order where there's chaos. And what the pool always does is provide like an additional stream where people can get these licenses while the bilateral license still stays available. So what does that mean for us? We go into a negotiation with companies that are all very different from each other. We are representing companies that are R&D institutes or are giant telecom giants. And we try to reconcile these different visions that these companies have. In some of our pools, some of our licensees are also licensors, so some of them are actually net payers instead of receivers of royalties. So we need to balance these things to each other, and that's a negotiation process. And that's a negotiation process that can take a very long time, and sometimes it can take up to 2 years, maybe 3 years. If you have pools that are with very like-minded patent owners, you still spend 1.5 years at minimum to get together on what the pool should look like, what the royalties should be, what are the terms that we're going to offer, how are we going to split the royalties between each other, how much are we paying, etc. So it is already a negotiation. Then there's an additional party there, that's Sisvel, because we need to go out into the market and license these licenses with our own licensing team, and we need to believe in what we sell. So I don't want to go into the market with a royalty rate that I think is indefensible, will only end me up with a lot of long discussions and end up in litigation, because litigation is kind of where we step aside and the lawyers step in. So that's not really the goal that we have. So to achieve that goal, what we do is we hire economic experts, try to figure out what is the right royalty for a market that may be new, that may half exist, like an IoT, or that is just in development, so for example, Wi-Fi 6 or Wi-Fi 7, and we figure out what could be the right aggregate royalty rate for this market, and then what do we represent with all these patent owners, and then we can see how we can negotiate with these patent owners to come together to come to a royalty rate that makes sense. And this is all before we start an actual licensing discussion with a potential licensee. So that's the process that we go in, and I think this is a process where we have as a goal to suppress as much possible the royalty rate, because the pool can only be successful if our commercial offering is more attractive than the sum of all the bilateral licenses together. If that's the case, if the sum of the bilateral licenses together and all the negotiation that comes with it is a cheaper option, is a better option for you, then you need to tell us, because we need to go back to our patent owners and ask them, hey, I think we need to revise our policies as a pool because it doesn't make sense. And that's something that is an ongoing process in a pool. Now, when we go out to license our patents, things kind of start to become different, because now we've set the rules with the patent owners after a long process. We think we're right, but now we're going to test it with the market. So we're going to go around, have negotiations with many companies, and see what the feedback is. If we think that we're on the right track, we're going to continue. If we think we're completely wrong, we're going to see if we have to make some tweaks to how we do things, because we don't think that we completely miss, but maybe we can hit the ball better. And once we start to license first companies, then that's when France comes into play on the non-discriminatory side. That means that once we get a couple of, especially larger licensees come in and take the rates for what they are, that they agree with them and they say, look, don't tell who I am, but I'm still going to pay. That's the moment that we also have a signal that this is an acceptable rate for serious companies, and that if companies are unwilling to take a license, that we have to go back to the patent owner and say, well, we're going to be stuck with a couple of these companies, and you have to figure out what you want to do with that. Because Sisvel, unless we have our own patents, can only represent the patents that we own. We cannot represent the patents that other patent owners own. So that lands me to the different licensing environment that we enter into as a pool, because it is very similar to what Julia was describing, and also what I heard about long exchanges, about emails. I mean, we've seen everything. There is a reality in the market that, and that's normal, I think, in any competitive market, that companies want to cut costs. If a company can decide not to pay anything, they won't. It's very simple. And sometimes that's by design. We know companies that you can send them 20 reminder letters in 2 years, and the moment that they start talking to you is when one of the patent owners started the litigation, and they said, okay, you got our attention now. That's just a reality. We see this, especially with American companies, this normality of litigation as part of the process. But it's also sometimes by flaw of the company. I mean, if I'm talking to, and we see this, for example, in the IoT field, it just doesn't have priority to take licenses. They say, look, I have to figure out the design of my battery. I have to get down the cost of the SIM card of the operator. I have to secure my supply of SIM cards, etc. I've got this customer who has this design specs to make my module in a different way. I mean, these are all higher priority than actually taking the license. And then on top of it, as I was describing, there's this confusion about indemnifications and terms that are attached to the indemnifications, etc. So it's not always very straightforward. So what we do see is that in the end, there's always going to be a group of companies not taking these licenses. Now, one thing that's and so this is actually pretty much what Julia will also probably run into on a regular basis. What we have as an extra dimension in a pool is that we represent powerful patent owners. Huawei is in our Wi-Fi pool, for example. Ericsson is in our IoT pool. But we also represent small R&D efforts. We represent universities. Sometimes we have a single inventor. And these are the smaller patent owners that have valid patents that are used and that deserve a royalty. But if we go to companies, and this is especially true with the larger companies, and we tell them, look, this is our pool license, they tell me, David, I see this list of licensors you have. Sure, these 5, I believe that I need to pay them because otherwise they will start chasing me. But the rest, I don't really care about, and I don't think that I'm going to convince my management to pay for these patent owners. So we have a long tail of smaller patent owners that, by design, kind of can get ignored. And the consequence of this is that if this goes on for a long amount of time, these companies, these institutions, or whatever they are, basically have 2 choices. They can say, well, 3 choices. They can say, forget about it, I'm not going to make money. I don't care. The second thing that they can do is that they can start a litigation because they say, I want that they care about me, so I guess I have to make this investment. And the third option, okay, I told you. The third option that they have is that they sell their patents to a company that will pay them the value of their patents, and this company will litigate. And this is sad because I think that royalties are actually, I mean, in our philosophy, are meant to fuel a next round of R&D so that we can continue this cycle of innovation. So I'll stop.
That is brilliant. Thank you very much. Does anyone want to say anything before we go on to...
If I make a quick comment, so I can share experience from my research, doing a project with or about research institutions like Fraunhofer, known for video compression, but they're doing other things as well. And indeed, they have exactly these issues. They need to join pools that first a hard time maybe to get their contributions anyway into the standard, then to file patents because that's costly, and then to get a return on those. So that's definitely also an issue where pools can help, unless, of course, your licensees say, no, we're not going to take those because they're not going to litigate. That's
a dead end for us, by the way. We have to say no to those kind of requests always.
So this is good. So you help those, that is good.
Maybe. Yeah, you mentioned that like for some companies, it's not necessarily a priority to obtain a license, some implementers. And I think from our perspective, there are always two elements that come with it, because I think a lot of SMEs would be willing licensees, but we're often facing two main issues. The first one is that we sometimes feel that there is insufficient transparency with regards to the rates, which, whether we like it or not, requires us to spend time on our own assessments to understand, okay, how can we now bring another offer to the table that will contribute to the discussion? The second aspect is that we also sometimes experience a form of holdout, I would say, where we get very long response times, sometimes 8 months or more before getting a response to our licensing demand or to a follow-up to an initial licensing demand. So maybe my question to you, David, would be like, do you think that patent holders typically provide enough information to justify not only their rates, but also the value of the entire pool to the end product of a licensee?
I think it's a difficult question because I cannot answer for all the patent owners. I can answer for Sisvel. What we strive to do is to give that kind of transparency for our pools. So what we do is we evaluate patents. If you want to make money in our programs, you have to evaluate your patents. This is an outside agency that evaluates patents on a very strict brief just to evaluate, is it essential, yes or no? And only those patents are ending up in our pool. Those patents are ending up in our how do you call it, in our documentation. We select claim charts for licensing discussions. We got an actual team of engineers. We got 10 people who their job is to explain patents to people that we put into discussions, we make available. So we are trying to grant this kind of explanation about what is in our pool, what do we license. When we explain our rates, we try to come to some sort of evaluation of what does the total market look like, what is our position into it, etc. But it's always going to be difficult. I mean, just an example, in Wi-Fi, some companies may suggest otherwise with the reports that they're selling, but there's no database of standard essential patents in Wi-Fi at all. It just doesn't exist. Everything is a speculation in this market. So we have kind of methods to figure out that we are around this percentage in the world, and this is what we think we represent, and that's what we put in our negotiations. But by nature, that's just not always there. So that is something that we try to do. I mean, and in IoT, we even went a whole lot further. We got a whole website dedicated to explaining what patent pools are, what SEP licensing is, what SEPs are, what standards are, etc., specifically directed to the IoT market, knowing that the people who are going to read it are not lawyers. So we try to make it as simple as possible, as accessible as possible. But still then, it needs to be a priority. And still then, I mean, if you cannot figure out how to get the battery working in your product, patent licensing is not going to be your biggest concern. So, but it doesn't mean that it's not important.
It isn't. Can I just... yeah, I concur with you, David, there. Because it might not be a priority for the IoT companies, SEP licensing, as of now, because they don't have the internal resources or whatever. But it is important to raise awareness so they can know already in advance that they will have to pay for it at some point, or they can even, become interested in standardization. And they will have to address that at some point, and the costs, they can maybe figure it out from the patent pool, so, published rates. So I think that's very important. And that's bringing transparency.
Okay.
Go ahead.
No,
go for
if you have one more, I was going to go to one last thought in less than a minute, but if you have something you particularly want to say on this,
I'll just take it as my minute and,
do that.
and cede my time to the board. I find it interesting. There's a lot of discussion about what is the intent of the implementers without any one of you looking to the implementer that's on the panel. I also want to say that pools try to state that they're one-stop shopping, multiple patent owners come together, you can get a license. Typically, historically, that has some benefit to us when you have a pretty unified, what I'll say, product category, smartphones to tablets to laptops. There's a good grayscale there. Right now, we have EV chargers, we have smart meters, we have all kinds of, Schneider Electric products is in the thousands. We have circuit breakers, and we have medium voltage transformers. None of these are in a pool. I have to go bilateral. I do, because of the very nature that the pools do not meet my needs and are inflexible in those product definitions. And so to characterize these conversations that I have with my indemnitors and my leadership about how this pool isn't meeting or going to meet our long-term needs, as I think I wrote down, I'm trying to cut costs and therefore I ignore you over the confusion with my suppliers, I think doesn't really give us a fair chance of having a willing licensee. And I will point you to the U-Blocks case, where they are a willing licensee, came to court cases to try and drive a license with patent owners, and the patent owners refused to license them because U-Blocks is farther up the supply chain at the component level and not at the consumer level. And so it's a complex marketplace. There are a lot of drivers, and I've gone over my minute, but I do think giving everybody a little grace as opposed to characterizing them would be helpful to creating trust and integrity in these negotiations. Thank you.
You get to come back in your minute, not now. Joachim, final thought.
A final thought. Maybe one on pools. So very helpful in principle, where they exist, where they group things together. But it's rare that they achieve close to full coverage. And so it's a nice solution I would like to have, but it's apparently hard to build. And what you just confirmed, in the IoT space, where it's getting more and more fragmented and diverse, it's going to be even worse. I also think one way to address that would be licensing further upstream in the value chain, which is, as I said earlier, the normal case in most industries, because the number of firms upstream is typically much smaller. The number of firms making Wi-Fi modules is much smaller than the firms building Wi-Fi devices, probably a factor of many hundreds of thousands. And then, of course, you also don't face that issue that, as you said, they say they have other priorities than taking a SEP license, which is not quite nice in terms of delay, but it's maybe simply true because it's a small firm, they have many things to do. And if they could buy the stuff fully licensed, as again is the normal case in most industries, things would be simpler. Maybe we should think more about that.
Ilya.
Okay, so I agree with Carole in a way that I think we need to allow discussions between patent holders and implementers, even the pools, to address licensing challenges, because for new markets, it's or markets new to adopting standardized technologies, it's challenging for them, but also for the SEP holders, I think. That's why I believe patent pools IoT patent pool hasn't addressed all the use cases. No. That's maybe why. So I think we need to continue dialogue. I think that's very, very important. It won't be, I mean, it can be addressed in court, but it won't be in court that there will be a consensus amongst the players in the industry. So that's something I want to say. And also one just personal comment on the SEP regulations. I think by the time, if they do come to law, by the time they do, it will be too late to address the current challenges. So that's a very important aspect. And it will be too late in terms of companies having to know how much the license will cost, how it will be addressed, how it will be licensed. where in the value chain, so in the supply chain. So I think, yeah, so that's, sorry, more than a minute.
David, do you want to go?
Yes, so first of all, Carole, I mean, I was definitely not talking about Schneider Electric when referring to these companies. I was just describing the different kind of flavors that there exist, because that ties into also, I think, my thoughts for my final minute is that our experience is the vast majority of all licensing matters in SEPs is handled amicably. Litigations are outliers. Usually when we see litigations, it is with companies that tend to end up in court very often, which I think shows some sort of cadence, some sort of rhythm that these companies are following. Personally, I'm not even convinced that that is a bad thing. I think courts exist in our society to find resolution in disputes where parties find it difficult to come together. There's a fundamental function in our society, and to think that people going to court is a bad thing, I think is not a good thought. I think courts should be accessible because we're talking about justice here. So I think that if companies find it better to resolve their differences in court, so be it. If they need the scrutiny and the process that the court provides to help them come together, I think that is something that is valuable. But let's focus also that the vast majority of these licensing cases does not end up in front of a judge.
Thank you. Lukas,
It's my final minute.
your final. It's all down to you now.
So I think maybe just for closing thoughts, I would like to join Carole on the fact that the SEP licensing market requires still greater transparency and predictability. What the proposal, as incomplete as it may be considered by some, I think acknowledges is that SEP licensing is not a zero-sum game. By addressing systemic challenges, a well-honed regulation could enlarge the market by encouraging more proactive licensing by all implementers, and also reducing transactional costs for all patent holders.
That is great. Thank you very much. We hand you back. All yours, Benno.